All right. Hello, everyone. Welcome, welcome, welcome. I know you're probably all very stressed and overwhelmed. This is just practice. It'll be real on Monday. Ready to start? Okay. Facts and Peer post, please. What's your name?
Ayana.
I'm Josh. Good to see you.
So Pearson, I didn't do a brief for this.
Okay.
Can
you tell me the facts of the case, please?
So, I basically wrote that they were trying to decide if Pearson should give the fox.
Okay, so describe what happened to the fox. Let's talk about the facts.
So, it was Pearson who intercepted and killed the fox.
Okay. Who's Post?
Post was chasing the fox
okay.
with his dog.
Okay, good. So Post, okay, was that good? Very good. Okay, so Post was chasing a fox with his dogs and his hounds. Okay, good. Well, who's Pearson?
He was the person who came in and intercepted and killed the fox at the tent.
Oh, okay. Very good. Thank you. So you got it. Okay. So now what's your name?
Sarah Mirena.
Okay, Sarah, thank you. So let me ask you a question, please. We have this conflict, right? Post is a hunter. He's chasing the fox with his hounds and everything else. Pearson, who's Pearson? Where did he come from? She said Pearson intercepted the fox. Where did Pearson come from?
It was his land.
Did it say that in the case?
I don't think so.
No. So do we know anything about where Pearson came from?
Not that I know.
Okay. Do we know how Pearson intercepted the fox?
I guess he saw that Post was chasing the fox with his hounds, and he decided to intercept.
He decided to intercept. Okay. So, search your name?
Jeff.
Jeff. So, Jeff, in the end, who actually came away with the fox? Pearson or Post?
I believe that Pearson killed it for himself and went on about he saw them chasing.
Right.
He said he didn't see his party.
Right.
And he ended up killing the fox.
Okay, very good. So then how did this case get to court, Jeff?
I believe it property law case, and that was you.
Who sued who? Let's just make sure we get the what's called the posture. Everyone knows the word posture. They tell you this word. Posture means who are the parties, right? How did this case be? It's not like you're slouching in your chair, right? Posture means what happened in this case. How did it get there? So, Jeff, what's the posture of this case? How did it begin?
Did Post end up suing Pearson?
Exactly. Very good. Okay. Post, the hunter, he files a lawsuit against Pearson, the interceptor, right? All right. So, what's your name?
Jason.
Jason. Okay, Jason. Let me ask you a question, please. Who does the lower court rule in favor of?
In the case of Pearson v. Post, they rule in favor.
The lower court.
Yes. In the lower court.
So just to be clear, the case I gave you, which court was that in?
That was the appellate court.
Right. It was called the New York Supreme Court, so the highest court in New York. Very good. So I'm asking the trial court, the lower court.
Pearson, they found in favor of Post.
Correct. How do you know that?
because Pearson, not very happy with the outcome, took it to the Court of Appeals.
Exactly. So here's a rule that you can remember, right? You always see the name of a case. It's called a caption. Pearson versus Post. Why is Pearson's name listed first? In any appellate case, you want to tell me? Well, that's not the reason. Yes, sir? Not exactly. Well, okay, so in the trial court, Sarah's correct. The first name is the plaintiff, and the second name is defendant. But on appeal, it's a little bit different. Yeah, in the back? He appealed, he lost. The party, this may sound obvious, but it's not. The party in the trial court that loses takes the appeal, right? If you lose, you appeal. And when you take the appeal, your name comes first. So Pearson, he's correct. His name's listed first. Why? Because Pearson lost in the lower court. Lower court ruled for Post. I'll get to why in a few minutes, okay? I promise you, your first week or two of class, you will have confusion with who is who. Because often the case will say the plaintiff and the defendant, and I'll never say which is which. And you sometimes have to figure it out from context. So if you forget everything else I said, the name that comes first, lost below. If you forget everything else, you remember that one tip. Okay. So the trial court ruled in favor of Post. All right. So then the case is appealed to the state Supreme Court, the highest court in the state. Okay, ma'am, what's your name?
Morgan.
Morgan. Does the state Supreme Court affirm or reverse the trial court?
They reverse.
They reverse. So who won after everything was said and done? The jerk, right? The interceptor. All right. So now let's go back and sort of analyze the arguments that Pearson and Post raised. Ma'am, what's your name?
Malia.
Malia?
Mhm.
What is the best argument that Post advances for why he should prevail?
That he was already in pursuit of the fox. He had put time, pounds, effort into pursuing the fox, and he was within reach of capturing him, basically.
Okay. So Post says, look, I didn't get the fox, right? I don't have it in my hands. But I put a lot of work into it, a lot of energy into it. I chased the fox. I had my dogs. I had my, all the accoutrements, and I was able to flush the fox out. And I got to a place where someone just swiped it. All right, that's just the basic argument. We'll go more in depth in a few minutes. And what's your name? Izzy. These classrooms are awful, by the way. They are. I've fallen many times. You'll take torts on Monday, right? This is a death trap. This is just made, and they're not accessible. These are just bad, poorly designed classes. It's terrible. Anyway, so I've fallen many times. I've gotten up, thankfully. Izzy, let me ask you this question, please. A little rusty, summer break, right? Gotta get warmed up. Izzy, let me ask you this question, please. What is the best argument that Pearson proposed for why he should prevail? Who actually laid hands on the fox? Did Post ever touch the fox? Never laid hands on it, did it? So what rule then, Izzy, just to sort of tie everything together, what rule did Pearson favor? What rule did he adopt, or would he prefer? When I say what rule, what test, what standard would he ask the court to adopt?
Oh, that it's his property.
No. What's the standard? In other words, what according to Pearson, what do you have to do to actually win in this case? Is injuring it enough? Is enough to like throw a rock at it?
I guess then lay hands on him.
What's that word?
Possession?
No, it's a funny word. Yeah.
Mortal injury or mortal
No, it's a funny word, not English. Yeah.
seizure?
No. Yeah. It's a different funny word. Anyone else? Yeah. No. It begins with an M. What? Not maim. That's injury. Begins with man. Anyone got it? Yeah. What? Mancupation. Close enough. Good. Good. Yeah. Like man, like mono, like hand, right? Mancupation literally means laying hands or putting your hands on the thing. So the rule that Pearson adopts, or Pearson would favor, is what you might call mancupation, the rule of capture. The first person who actually captures it with his hands prevails. All right, so we have these two rules, right? The first one says, no, let's focus on how much energy and labor you put into the hunt. That's from Post, the hunter. And the other rule that's put forward is by Pearson. It says, no. It's not enough to hunt it, you have to catch it. You need to have physical, bodily, hand touch mancupation. All right. Ma'am, what's your name again? Aaron. So which rule does the majority opinion adopt? Okay. Are you late or?
No, I'm very good.
Yeah. Okay.
In favor of Pearson, that means
Mancupation. Okay. And then just finish up. Which rule does the dissent adopt? Very good. All right. So I'm going to now explain why, or at least I'll try my best to explain why the court disagreed. But before I do that, I want to ask sort of a basic question that will make a bunch of you just want to rip your hair out. So did you say possession before?
I said C.
Seizure. Okay. What's seizure? And not like medical seizure. What's a seizure in this context?
When you take and get something from something.
What does it mean to take?
To take? In what context?
I don't know. You use the word, you tell me.
I imagine to take, to capture, to seize, to.
What does capture mean?
Capture is to gain or maintain possession.
But does capture necessarily require touching it?
Not
If
necessarily.
we throw a net. If you capture it, we throw a net over the fox?
Would you consider it captured until you've gotten the animal that's within the net?
You shoot it from 20 yards away and it dies. But then as you're walking up to the corpse, someone takes it.
You shot it, somebody else.
You
took
did,
it.
but you didn't lay hands on it, did you?
No, you didn't, but that seems unfair. You dealt mortal injury to it.
Mortal injury. Sir, what's possession? Someone used that word before. What's your name? Right here. No, with the stripes. Yeah. Brandon, what's possession?
I would say something that's in someone's hands or on their property.
What do you mean on their property? What's property?
Something they possess.
Oh, there it is. It usually takes one or two people to get to that point. Yeah. What's property? That's the name of this class, I think. What's possession? Your head spinning yet? Yeah.
Possession is, I would just say something they have on the body.
You have to touch the body.
No, like on you.
What if a fox crosses onto your farm? Is the fox yours?
Probably not.
No. Can I come on your property and then take the fox from you?
Probably not, but I don't.
Oh boy. What's your name? Yeah. Lucas, what's property? What's possession? What do these words all mean?
Property is the land that you own.
The land that you own. What does own mean?
It's mine.
Okay. What does mine mean? What does that mean? That something's yours. Who says? Says who? If you say it's mine, is that enough? What? Oh boy. You ready for this one? Sorry, you're next. What's your name?
Tyler.
Tyler, what's the law?
Oh.
You knew this is murder's row right here. This is just my favorite part of orientation. What's the law, Tyler? You're in law school. There's this law. What is this law? Damn good question.
Being a law is, I guess, what's governed by our courts, safeguarded by our courts.
Wait a minute. Wait. The courts tell us what the law is?
The courts enforce the law.
The courts
guess
enforce the
no.
law? Wait, Schoolhouse Rock. Which one is it?
So the courts interpret the law.
Courts interpret the law. Ah, okay. Ma'am, what's your name?
Paola.
Paola. What's the law? You tell me.
I would say the law is like the rules and regulations that we as a society have adopted, like
Do you and I get to make rules? Is that something we get to do? Is
as
that
acceptable.
who do we? You and I? Can we make rules?
Not you and I particularly, but people like us.
Ooh, what kind of people? You tell me. Who are these people? I don't know them. Legislative branch. So the legislative branch writes the laws. What do the courts do? At least they're supposed to do.
Um, well,
What do
we
we
know, we learned earlier, like, we know that they're technically supposed to interpret, but we know, like, in certain situations, sometimes they make the law.
Wait a minute. Wait, hold on. Wait a minute. Man, what's your name?
Kelly.
Kelly. The courts make law? Did I learn this all wrong in kindergarten? What's going on here?
For interpretations, they can make law.
Have you heard of the common law? What's that?
Common law is basically using previous cases to determine the future outcome of new cases.
So judges making law. Is that right? Did I get that right from your question?
I think so.
Huh. So what's your name?
Question?
Weston, let me ask you a question, please. Is there any statute or legislation passed by the New York government to decide how to handle Fox disputes? Is that like a bill that was passed in the last session?
Good question.
Yeah, that's what I'm asking you.
No,
Is any
not-
such
not
is, it,
that I know of.
is any such law referenced in the opinion? It's short.
Not that I know of.
Nothing's referenced. Okay. And so what's your name?
David.
David. You know, this was New York in early 1800s. We had this war 20 years earlier. Were there any sort of British laws that perhaps governed this dispute that might have been in effect at this time, do you think?
There were a few that they referenced in the
They
case.
did reference it, but were they in effect in the new country?
Well, that's part of the thing they tussled with is should they create new or should they create new precedent, or should they stick with the Judicial?
Okay. So we're kind of in a no man's land, right? Where we have a new country, brand new laws, no laws in the books, but we have some precedents from some courts across the Atlantic. We have a couple English cases, but not just English cases. We got some other authority. What's your name, sir?
Jeffrey.
Oh yeah, Jeffrey and Jeffrey. Okay, two in a row, right? Jeffrey, what kind of laws can a court look to when it's making a decision? What are the different categories of laws that might be looked to?
Previous pieces.
Well, but these were cases from a different country, weren't they?
Yeah, but yes, still common law.
Still common law. What are some of the other sources of law that the opinions majority and dissent look to? They reference a bunch of names that you've probably never seen before.
Previous English case.
Well, they weren't just English. And sir, what's your name?
Josh.
Oh, well, Josh too. Good to meet you. Josh, what kind of sources, what kind of authorities did the judges look to beyond just English cases? They looked at like some weird stuff.
Philosophers.
Philosophers? Who the heck are philosophers?
Well, Locke. I mean, I know Locke. I mean, that's pretty much the only one I know.
Whoa. Okay, so you may have heard of John Locke, right? Why on earth are New York courts citing not judges, not legislators, but philosophers? What's going on there, Josh?
Well, when you don't have anything else to base it off of, you have to kind of
Ooh.
look to other sources.
Okay, now we get to the root of the issue, right? Why am I giving you a case about foxes? Do we care about foxes today? Maybe you do. It's a bad question, but this is not a dispute that's in any way relevant to our lives today. But it is. Why? It teaches you at the most basic level how courts function. They have a dispute. These two guys are fighting over a fox. The judges have to say something. They have to rule. There's no legislation, right? There's no precedence from New York courts. So what do? They turn to what we might call first principles, right? The very basic law. So they looked at John Locke, who was an English philosopher. What's your name? Mason. What other sources does the majority and dissent refer? They list a bunch of names. Maybe you've never heard of these names. That's okay. Do you have it? I'll come back to you, Mason.
I don't
And
know that I would think.
That's fine. What's your name?
Julia Grace.
Julia. Okay. Thank you. Hoofendorf. My goodness, like a Harry Potter thing, right? Hoofendorf, right? What else they got? That's fine. Barbarac, that's good. Grotius, very good, very good. Tag teaming, that's good. One more, really old one. Anyone? Justinian. All right, so who the heck are these people? And if you don't know, you should look it up. Right? I'll give you just a rule of thumb. If you read a case and you don't know a word, look it up. Black's Law Dictionary. Do you have Westlaw? You have a Westlaw account? Black's Law Dictionary is on Westlaw. Look it up. If you need Google, if you're in a pinch, just Google it. But you don't want a professor saying, "What does this word mean?" And you say, "Oh, I don't know." And they're like, "Did you look in the dictionary?" Like, no. Okay, avoid that, right? You don't want to be that person who didn't know what a word means. It takes you 3 seconds to look it up. So who are these people? These are different writers on what we call the common law or the natural law. You call it many different things. But these people wrote about very basic principles of how do you acquire ownership in an animal, right? These are rules that have been around for hundreds of years, in some cases 1,000 years. Now, sir, what's your name? Dallas? Why do we care what these philosophers thought? I mean, Justinian was Roman. Talk about the Roman Empire, right? Why on earth would a court in the year 1800 care what a Roman emperor thought about foxes?
We base a lot of our government on, the Roman Republic and the Greek Republic.
Why? That was so long ago. They're very different people, very different times. Why do we care what the Romans thought about our law? I think Richard Epstein's going to strike me with a bolt of lightning. But why do we care what the Romans think? Phone a friend. Not really, but maybe an orientation. Sir, what's your name?
Chris.
Chris, help your friend out. Why do we care what the Romans think about property law?
Is that very successful, long-lasting government?
Oh, that's interesting. So if it worked for them, maybe it works for us?
Yes.
Do we still read Roman law, 2,000 years later? Maybe not you, but do people still read? Do people still study Roman law 2,000 years later? Yeah, they do. I think you gave me the answer why. Why do we still study law from these long dead civilizations?
Because they seem to have known what they're doing.
Yeah. And so what's your name? Campbell, if let's say there was some civilization that passed had these really bad laws, very dumb laws, and people sort of forgotten about them. Do you think we'd still be reading about them? No. Why?
They're dumb laws that won't have much relevance to what we're doing.
So what you're telling me, I think, is that the reason why these really old laws have stood the test of time is because they make sense. Is that a good summary of what they just said? I think they're right. So much of what you'll be studying your first semester is really old law from people who are quite different from us, right? And that might be a reason to sort of just reject saying, "Oh, I don't care. There's different times, different people. I don't care." But once you get past that initial, talking point and just dig like a couple inches deeper, you realize it's been around for a long time, and we're still talking about it for a reason because the rule makes sense, right? There was some wisdom that's been acquired over the centuries and millennia, and that these principles from a long ago time with very different people still have some relevance to what it is that we are doing today. Indeed, this is the case, right? You have a fox hunt and you don't know how to resolve it. You don't have a statute. So the judges do what they have to. They turn back to first principles, to the sort of natural law reasoning of who gets the animal. Everyone with me so far? Now, wouldn't it be really simple if all these ancient writers agreed and they had the exact same perspective? Wouldn't that be really easy for your law school class? But you're going to find, my friends, that is not often the case. That authorities, even long ago, don't always line up perfectly. Sometimes the authorities even go in different directions. So then it falls to the courts to decide which authority do we find more persuasive? Which authority do we follow? And this is sort of where judges make, I won't say make the big bucks, they don't make a lot of money, but this is where judges sort of earn their medal, their honor, if you will. It's by persuasion, right? Which line of authorities is more persuasive? So, so what's your name?
Josh.
We got 2 Joshes and 2 Jeffs. I love it. Okay, good. Josh number 2. Sorry, you're number 1 by location. So Josh, let me ask this question, please. Which line of sort of philosophers does the majority find more persuasive? Which sort of category, which theory do they find more persuasive, the majority opinion?
Can you go further? I don't.
Which rule, we said before, which rule does the majority adopt?
Oh, the emancipation.
Mancupation, rule of capture, right? Which of the philosophers sort of favor that rule of mancupation? They have to actually capture it. Uffendorf is good. Okay. What rule do they put forward to capture an animal? What must you actually have to do?
Being possession of it, or
Like, what about a net? Would a net be enough?
I think so, personally.
Mm-hmm.
I think they mentioned a trap in here.
A trap? Okay. And so what's your name?
Matt.
Matt? With throwing a net on a fox, such as trapped, would that be enough for the majority's theory to capture the animal?
Yes, I think it would be enough
Why?
because it has to do with control.
Good. What are you doing to an animal by throwing a net over it?
You are controlling its actions. You are in.
You're close.
Here.
What are you doing to the animal?
You're depriving it of its natural.
Perfect. That's the answer. That's exactly what I was looking for. Thank you. And I think someone mentioned before, I told you I'd come back to it. The majority adopts what's known as the rule of capture. They have to actually capture the animal. But that doesn't mean doesn't require you to actually lay hands on it. You can also capture the animal by depriving it of its natural liberty. Depriving it of its natural liberty. Okay, that's what our friend Matt just said a moment ago. Ma'am, what's your name? Jane. What does it mean to deprive an animal of its natural liberty? What does that mean?
No longer be
I can't even. No longer be what?
no longer be
Feral. Can't roam free. Okay, so you're limiting its mobility. Okay, so if you throw a net over a fox, have you deprived of its natural liberty? If you throw a rock at it and it's sort of stumbling around, but it can still run away.
Can you run away fast?
It's hobbling. It's walking slowly. You know, is that enough to?
Almost there, but no.
Not quite. Not close enough, right? I think she's right. This concept of natural liberty requires things limiting its mobility. So a net, maybe throw a rope around its feet or something, right? A trap. But if you just throw a rock at it and hit it and it still runs away, it's still fair game, right? It's still fair game, right? So the rule of capture that the majority adopts doesn't require always mancupation, that's holding with your hand, but it's got to be enough to deprive the animal of its natural liberty. Everyone see the majority rule. And that cites Justinian, cites Grotius and Pufendorf and a few others. Ma'am, what's your name? Macy. What's the rule that the dissent would adopt? Which philosophers does the dissent find persuasive? No, it was. He said Barbarac for the wrong one, right? What did Barbarac say? And by the way, Barbarac was a student of John Locke. That's what I mentioned Locke before. Not student, but he studied him.
avoid giving offense to advocacy.
I can't hear you. Describe your own words. What rule did the dissent favor?
Not the person who lifted the case, not the person looking at the threat phone.
Okay, so we're talking about the hunter who's in the process. But what's the test? What test will the dissent favor? Puts forward a test.
Sure.
Ma'am, what's your name?
Jasmine.
Jasmine, what test would the dissent favor?
The pursuit of it, like the
Okay. How close do you have to get in the pursuit to acquire the animal under the dissent's theory? How close? Macy, you have it now?
Was it having to see someone, like how to pursue the animal?
Right, but you don't have to actually touch it. So, ma'am, what's your name? Julie, how close do you have to get to acquire an animal under the dissent's theory?
Close enough for animal to not be able to escape and that would establish it.
Did you make that up? Where is that in the case? So it's close enough? Is that the words it's using? Because a particular test doesn't give a specific distance. No?
You can reach.
No. Sir, over there? What's the test that dissent puts forward? With a tan shirt, yeah.
I think they, obviously talked about the effort, but if it takes
What's the test? Yeah. What's your name?
Sergio,
Sergio, what's the test?
I'm not sure, but I think it was the effort to initiate the chase and the following through the chase.
Not the effort to initiate it. Sir, what's your name? George, what's the test the dissent puts forward? There's a specific phrase in the opinion that you should all have gotten. Yeah. No. Yeah. That's it. Say it again. Right. The dissent says, does the person have a reasonable prospect of capturing it? It doesn't say you have to within reach, within 5 feet or 10 feet or anything else. Does he have a reasonable prospect of capturing the animal? Okay. Now, was it Jane before? No, I'm sorry, it was Jane. No, what was your name again? Yeah. It's close, Julie. JJ. Julie, so how do you know then whether an animal is within the reasonable prospect of being caught by a hunter? What does reasonable mean? I think you're on the right track. Just give me a little bit more.
I would say that reasonable process means as long as you have somebody can deem reasonably that you're able to catch them.
Oh man. Okay, so what's your name again? Tomas. I'm going to ask you a question. You're going to hate me. I'm sorry. What does reasonable mean? You trust me. You're going to have so many reasonable standards in law school. What does reasonable mean? Is that what I think is reasonable? Is it what I think is reasonable? What you think is reasonable? What does reasonable mean?
I guess that would depend on the person you're asking, but whatever they.
So is it based on what any particular person thinks is reasonable? What the judge thinks is reasonable? What does reasonable mean?
I think in this case, what the judge thinks is within reason.
Sergio, or is it what a hunter might think is reasonable?
Yeah, I think what a hunter might think is reasonable, what a person of the community might think is
Interesting. What do you mean person in the community? Just tell me a little bit what you think by that.
someone who lives in the area, someone who is used or related to this life.
Oh, that's interesting. So George, I'll come back to you. Does the dissent even think this should be a dispute resolved by judges?
Not sure.
You read the case?
Yeah, I did.
He talks about this point.
I think they didn't.
Who does the dissent think should resolve this dispute?
The Shouldn't it be resolved, amongst them, amongst themselves?
Among which community, to use Sergio's word?
Isn't it like the two parties involved?
Yeah, we know the two parties hate each other, right? I'm asking which community should be deciding this dispute?
Hunters?
Hunters. Hunters. Why is this case even in court? What do these judges even know about hunting? I mean, have these judges ever hunted fox before? We have no idea. Think about it. Any hunters here? Punch. All right. Oh, good. You're next. Perfect, right? What's your name? Matthew. So let's say that you were like Mr. Post, you were a hunter and you're cornering some animal, right? And then some jerk comes along and takes your kill. What do you do? Be honest. Yeah.
I mean, if I'm on his property,
No. You're in a public park, public hunting facility. No one's property.
I'm gonna get into it with him about it.
You can get into it with them. Okay.
Fine.
Without character fitness problems, what does that mean? Get into it.
I'm gonna fight for what's mine.
You're gonna punch him? All right. We're not gonna. You know what battery is? Nothing. You put in a your car. Okay. So we don't get battery. Okay. Who else is a hunter? Might handle it a little differently. Yeah, in the corner. Yeah.
I would definitely call it game.
Since you're both armed, you know what? I think that's a fair point. So you call the game warden. What do you think the game warden would do in that situation?
He would probably, depending on what it is, probably just take it for himself.
The warden would take it for himself and give it pelt to who?
To like Salvation Army or
Is that what they do? They just give it away when there's a conflict?
probably not every time, but if it's a bird or something, not a fox, it would be worth some money.
All right. Anyone else? Any other hunters in the room? Yes, ma'am. What's your name?
Kendall.
Kendall. What would you do? Would you get into it with him?
Game warden.
Game warden.
No, not get into it with them. And then depending on who actually has the license or not, which the game warden would check, then whoever has like tags.
Okay, so they're tiebreakers then, right? If one doesn't have a license, you give it to the guy with the license. Is that the idea? All right, last one. Josh, what's your hand up?
Did I do it? I didn't shoot.
No. You're just chasing it. You're in the same facts as Mr. Post. You did not shoot it. You just got close. You kind of flushed it out. You cornered it, and then someone comes and takes it.
I would probably follow suit with them then. I mean, I would call a game warden, and then if we both have
Right.
the license, I'd probably be like, okay, you got it first.
You would not get into it with him.
Yeah, no, I would.
Okay, that's fair. I would not get into it with anyone. It's a bad idea for your lawyer. Yeah, we sue. We do it in the courts. Okay, thank you for that. But the point is, there's at least some tradition or custom of how to handle disputes. You call the warden, right? And I think Kendall said, do they have the right licenses? Do they have the right tags? Do they have the right permissions, and so on? Maybe you just donate it. Maybe you just sell the pelts and split the monetary value, right? There are many ways I think hunters could probably handle this dispute. But Pearson and Post chose what might be the worst possible way to go to judges, right? Who know nothing about this field. They're not hunters. And instead of asking what hunters would do in the year 1803, they go back in time and ask what the Romans would do. So, where am I to? Yes, ma'am, what's your name? Mallory. Let me ask you the question then. But I think, look, we'll be honest. Let's be objective for a minute. I think the majority has a good rule. You have to either lay hands on it or get, or do something to deprive the animal of its liberty. That's a good rule, right? That makes sense. The dissent, I think, also has a good rule. You have to be within a reasonable prospect of capturing the animal. Why would a judge pick one rule over the other? These are both sound rules. They both have support. They both seem around for a long time. Why pick one rule over the other?
I think if one is more like applicable to a certain setting,
Applicable. What does that mean? That's a good law school word.
like relevant to the specific situation.
Well, why is one rule more relevant than the other? They both seem pretty relevant to me.
I think like if hound hunting and the use of hounds like wasn't common practice among hunters, like that rule wouldn't.
Okay. And what's your name? Crystal, you're a judge. How do you pick which rule to apply? I mean, both rules seem pretty reasonable to me. The facts are what they are. I'm asking you, given the facts as they are, which rule do you apply? Yeah, you're a judge. I just gave you a promotion. Congratulations. Why do you pick mancupation? Oh, that's the rule. You told me the rule. Why do you pick that rule over the rule of the labor theory, investing labor into it.
Possession of something.
What's the benefit of the rule of mancupation? Why is that a good rule to adopt? What are the sort of the policy reasons why you favor that rule? Sir, what's your name?
Jason.
Jason, why would you adopt the mancupation rule? She says she likes it. What are the benefits? What are the policy reasons why you might favor that rule?
Favor mancupation for the reasons that it would, I guess you could say, it would help for like other reasons. For example,
What are the reasons? Good.
someone starts, if we follow suit with the other law, there could be problems like they state of if you just start chasing the game, everyone else could claim to be chasing a game and take.
Oh, you give me a very good answer. Let me actually flip my question around because I think you might handle it a little bit better. What's the downside of the sort of labor theory, this reasonable prospect theory? What's the downside of the dissent's rule?
The downside would be that anyone could claim to have put effort forth for any piece of game that was in reasonable
Yeah.
prospect of gathering.
And do we believe people?
Not always.
We do not. People lie. In this class, property, people lie about everything. Trust me. They get into it. The truth gets blurry, right? So one of the downsides of the dissent's theory is evidence, right? How do we have enough evidence of was there really a hunt? How close did they get? Was there a reasonable prospect? There were no cameras back then. People weren't like having body cameras on their hunts, right? That wasn't a thing then. You have no idea. It's he said, she said. But what is the benefit of having the mancupation rule? What do you know you have with that rule?
You know that you have the evidence of who actually
Got it.
the animal.
It's a clear rule of evidence to apply. I got the thing. It's right here. It's mine, right? I got the fox. It's in my hand. No dispute. Versus, well, I chased it for 3 hours with my foxes, and we went here, we went there. Who the heck knows if they're telling the truth, right? We have no idea. So you might favor the mancupation rule because it's very easy to apply. It's very easy to put forward because it's an evidentiary rule, right? It provides certainty, clarity. You catch it, it's yours. There's no balancing of how close did you get and how many dogs did you have and how big were the dogs, right? No one cares. Do you got it or not? And what's your name? Charlotte. What's though the sort of downside of this mancupation rule, this rule of capture? Why is it what's sort of the negative consequence of such a rule? It encourages blatant taking. So you think Pearson was misbehaving here?
This gets into the issue of, like, it's like when someone someone stole my parking spot.
Oh, you hate when that happens, right? Yeah.
And so it's,
You've been circling and circling looking for it, and then you're bad to pull on these, go like this, right? Or they go from the other way. At the zoo, you're prepping at the zoo. Oh my God, it's so worse. You have children, right? And you're looking for a spot at the zoo, and you finally find when someone swoops in. Get into it, right? Don't get into it. So, but Charlotte makes a good point, right? Post put a lot of work into this hunt, right? Sue me telling the truth. And then someone swooped in and took the fox. So it encourages bad behavior. Oh, hello, you're here. What's your name?
Madison.
Madison, okay. There's a Mason and a Madison. Got good framers of the Constitution. George Mason. Anyway. So, Madison, what do we say about Mr. Pearson's conduct, that he stole the fox and he won? How would we sort of characterize that ruling? Imagine like one word you could pick. It's not fill in the blank.
It's not what?
It's not fill in the blank. What word would you put? This ruling is not blank.
I want to say it was selfish, but not.
So what's your name?
Leo.
Leo, what word am I thinking of?
Fair.
My hint was going to be it's a 4-letter word begins with the F,
Yeah.
right? But I didn't have to give you a hint. Good. Fair. Why is this ruling not fair, Leo?
Because it takes away all the work that posted done.
What? You're going to hate me. Man, what's your name?
Mia.
Mia, what does fair mean? Sorry. What's fair? We all say this word. Okay, it's not fair, right? Every kid says this. Oh boy, what does morally correct mean, my friend? You just walked. According to which standards? Oh boy. Kendall, what's fair?
Thank you.
You're welcome.
I guess it depends on your bias.
So look, the advantage of the rule of capture is it's clear, right? There's no morality involved. There's no balancing, right? It's a rule. You can apply it. You don't really have to care who's right or wrong. But the mancupation rule is, according to a lot of people, not fair. How can it be that someone invested all this labor into a hunt and they got nothing to show for it, right? But I think my probing of Mia and Kendall demonstrates not everyone agrees what fair means. Maybe you might think fair means a clear rule that's easy to apply. That seems fair to me, right? The rule of capture seems pretty darn fair to me. And if you know that's the rule, maybe you don't go hunting, right? If you know that someone can swoop in and take your fox, maybe just don't waste your time. Wait a minute. Don't we want to encourage hunting? Isn't this a useful profession? Maybe you don't think it is. Maybe you think hunting should be banned, right? That's a fair point, right? But if you don't think hunting should even, be banned, maybe which rule do we adopt? So really, when I asked the question before of which rule do you adopt to Julia? No, yeah, Crystal. So Julia is somewhere else. I usually have. Oh, I'm in the right line, right? I usually have 10 cards with names. That's why I learn them quicker. I have your roster somewhere. When you're deciding which rule to apply, it's really a reflection of who you are as a judge and what matters to you, right? Does it matter to you have a clear rule that's easy to apply? Or does it matter to you that you have some sort of equitable rule that sort of rewards good conduct and promotes good behavior and punishes bad behavior? And neither is right or wrong. Don't misunderstand me. I'm not saying that the majority is right and the dissent's wrong. By the way, the dissent and the majority, they're both right in different ways, but they're talking about sort of different issues, and they often talk past each other. You see this a lot in court decisions. So the reason why we give you this case in the first day of law school, orientation, is it teaches you at the most basic level how courts decide cases, right? What authorities do they use? What sort of rules or policies they find persuasive? How do they settle these disputes, right? And at bottom, what are we arguing about? A fox, which someone said the value of a fox pelt is, how much does a fox pelt might cost? Do you even know?
I don't know.
I think it was about $20 back in the 1800s. So I mean, it's a sizable amount, but not a lot, right? They're fighting over a fox. And by the way, these guys hated each other. They had you probably have guessed that, right? They have a long running feud between the two of them. And they took this all to the highest court in New York, right? They took this to the highest court in New York. And just to make this point even more blunt, the majority is by Judge Tompkins. He became governor of New York and became vice president. Big deal, right? The dissent, Justice Livingston, he went to the U.S. Supreme Court. So these were judges who went to become vice president and Supreme Court judge, arguing about a fox. So this was a big deal back in the 1800s, right? This actually really mattered. And we still say this case every semester. I promise you'll have property in the spring. You will say this case the first week or two of class. All right. I'm going to pause here and ask for questions in the case. Then let you ask me questions about law school and everything else. So any questions on the case? Yes, sir.
So in this situation, could a judge choose to go the barbaric route
Sure.
and then default to the if there's no evidence?
Well, I mean, one of the perks of being a judge in New York in 1803 is you can do whatever you want because there's really no authority. I mean, that perhaps is true today as well. But this was truly a blank slate that they were writing upon. And you will see other cases. You'll do a case involving whale hunting, right? A fox is somewhat easy to hunt because you can kill it, pick it up, and walk away with it. If you kill a whale, you can't exactly pick it up and put it in your back pocket, right? So the way you actually kill a whale, or at least killed it back in the day, was you would throw this what's called a bomb lance. Basically, imagine a harpoon with a rocket, and you would shoot a harpoon into the whale where it would explode. The whale would die, sink to the bottom of the sea, and then eventually float and then wash ashore. And then someone would find the whale. And that creates a dilemma. How do you get the whale from whatever beach back to the rightful owner? In other words, how will anyone know who actually killed the beast? Why wouldn't just the person who finds it keeps the whale? Because the harpoon had a certain symbol on it, and that looked like a star. And that was like a brand. Think of like a brand on a cow. And they use that brand to help indicate who actually owned the animal. So all these different rules develop for different types of animals. How do you capture bees? right? You can't like put a bee in your hand. You have to mark the hive, right? All these various rules developed to capture different types of animals. They developed in this sort of common law fashion, but all variations of the rule of capture as well. Other questions about the case? Yes, ma'am.
So, earlier you said that, because there wasn't precedent from other courts, they had to go back to philosophers and what they wrote about it. And like the reason why they did that is because it worked like in the Roman Empire, the Roman time. So why wouldn't it like work for this? But then like we also established that like the philosophers that they were citing, those people didn't agree.
No, I
So
did not.
how did they choose this?
That was my question to the back row, wasn't it? You have to. Everyone has certain. I'll use the word principles. It's not a very good word, but I'll use it. Different things they find important. Some judges might favor a rule that's very clear and easy to apply, certainty, if you will. Other judges might favor what you might call fairness, a rule that's equitable. And when a person becomes a judge, they bring to the bench with them certain philosophies, if you will, and that really decides which argument they find more persuasive. Because look, if both sides have lawyers and they put briefs forward or arguments, at least they're persuasive. Yeah, pick one. You will do different types of thinking in law school, right? One is sort of advocacy. That is, they'll say, you are representing Mr. Pearson, give it your all. Give the best argument for Pearson you can. Other times it'll be objective. For example, write a memorandum that's objective, that what is the best answer? And you have to sort of separate yourself from the question, not what you might think, but what objectively, the community, the standard, whatever it happens to be. And these are sort of difficult things that law students have to think about, how to sort of separate yourself. It's not easy. I don't pretend any of us do it particularly well, but it's something you should at least try to do. And judges, I do believe judges of all stripes try as best they can to separate themselves from the case. Whether they do it or not is a question that you'll decide by the end of your first year, I think, maybe your first week even. What else about the case? Yes, sir.
Did the majority have any effect on the ruling?
I'm
'Cause I
sorry.
know the majority decision was with
The jerk.
with Pearson. Did that have effect on the overall ruling, or was it just up to the judge and he didn't care?
Well, the majority was the ruling. I'm not sure I get your question.
Oh, okay, never mind. The
I mean-
majority was the rule.
Yeah, the majority of the court, that is the rule. So the New York court adopted the rule for Judge Mr. Pearson. What else? Yeah.
When the dissenting opinion makes his recommendation at the end, there's a part that confuses me. When he talks about relying on what Justinian says, when he talks about the nature of the dogs themselves.
He's joking.
Because of like empiricism.
Yeah, he's being sarcastic. He's saying we really have to measure how big the dogs are. Are they beagles or are they hounds? Right? I think I made this point. Like, are we really going to start looking to what kind of dogs these were and how long the hunt was? He's saying none. This is all kind of satirical. We shouldn't do this, but he has to decide. Even though he sort of mocks these philosophers, he still finds Barbarack more persuasive, which is kind of maybe unexpected. Good question. Close reading. What else? All right. So the 3 or 4 of you didn't get called on. You got lucky today. I can usually call on about 40 or 50 people per class. So I usually do a lot. All right. Let me sort of break character. All right. So this is probably what law school look like for you. Every professor is a little bit different. I usually call on a lot of people. I go up and down the rows, get maybe one question. If you don't give me a good answer, I might get a second question. But I go through a lot of people. Other professors you'll find do something different. They will call on one person for a very long period of time. You might be called for 30 minutes in a row. I don't say, oh no, yes, oh yes. Some professors make you stand when you give an answer. They call it reciting. I don't know why they call it reciting, but they'll ask you to recite a case and stand. You stand up. I remember I was once in law school. I had a professor like that. I was on call for I think about 45 minutes straight, and I was so exhausted. I just threw a question because they keep on you for giving questions correct. So I just threw a question because I want to be done with it. I do the answer, but you will be in that experience. Now, the best advice I can give you is going to be the hardest one to keep is don't fall behind the readings. You might look at the syllabus and think, oh, I have 20 pages of reading. That's what, 20, 30 minutes? No. No. How long did this 7-page case take you to read? Hour? 2 hours? Maybe 3 hours rereading a couple times? You have to learn to read a different type of English, and not just old English. Even modern cases have just jargon and way of writing that's not understandable to human beings. So when you look at your syllabus, whatever time you think it'll take you to read a case, double it, right? You might be in class about 20 something hours a week. That maybe means 40 hours a week of reading at home. This is a full-time job. I don't think any part-time students here? No? Okay, this is your full-time job. If you fall behind, you will invariably fall into a couple I call crutches. One of them is getting notes from your friends, or maybe notes from someone who took the class last year. I would not do that. The benefit of having notes is that you prepared them, you edited them, and the process of writing them or typing them helps you learn. Getting notes from someone else is not a shortcut. Another crutch that becomes very common is various commercial outlines, right? These are things that are available in the bookstore. We sell them. Maybe we shouldn't, but we do sell them. They're on Amazon. They're on Quimby. I know where these places are. These should not be used at least your first semester. Come talk to me after you get your first grades and we'll talk about it. But you might develop a dependency upon them, but you never actually learn how to read a case yourself. They'll give you these great summaries, right? These very crystal clear summaries written by very smart people. But then the professor will ask something that's not in there and it'll be immediately apparent. I know when someone's using a commercial outline. I know it very quickly. And I deliberately ask them questions that are not in there. Professors study these too. We know what's in there, what's not. So it's not a mystery. We know the sources you're using. So don't fall behind. You need to develop a pretty rigorous study schedule. Some of you will have study groups, maybe like learning with others. Some of you maybe will study by yourself. I don't have a silver bullet. People study differently, but you need to dedicate the hours. You can't skimp on sitting in front of the book or sitting in front of your screen and just reading it over and over again. There's no way around it. Professors will ask you to outline and brief cases in different ways. Someone said, I didn't brief the case, whatever. Every professor wants something different. And you unfortunately have 4 or 5 professors who want something completely different. And you have to accommodate each professor. I know it sounds unfair to use the word of the day. It's not fair, but this is life. This is law school. Make sure you meet with your professors. This I know sounds obvious, but people don't. You're paying a lot of money to be here. I never forget that. I know who pays my salary. You do, or at least the U.S. government, at least the interim, right? But use this to your advantage. Meet with your professors. Go to their office hours. And if something's not clicking, you ask them, and you just don't leave their office till it makes sense. I'm being serious. But too many people say, "Oh wow, it's 4 o'clock. I want to beat the traffic." I don't care. Stay till 7. Right? The library should be your second home. Maybe you have a great place at home that's quiet to study. Wonderful. Not everyone does. If you have a roommate or something, family, you need to spend time here. But now I'll give you the flip side of that. Law school is a marathon, not a sprint. Right? You don't want to burn yourself out. You still need time to basically exist as a person. So the challenge of law school, as with I suppose all of life, is finding a decent balance where you're able to sort of get your work done, but also not forget your family and friends. I know this sounds like impossible to even do, but it's a challenge. And if you do one too much versus the other too much, this won't work. You have to sort of figure a way to handle both of them. When it's going to come to final times, you won't have time to go out. You won't have time to see any friends for maybe a couple weeks. Understand, but it's a 3 or 4 semester slog, and then you'll be back here before you know it. November will be here. It'll be Thanksgiving, and you have to start exams. Okay, so that's my advice. Don't fall behind. Get to know professors and try to also be a human being. We have a couple minutes for questions if you have any. Happy to answer. I don't teach first semester, so you won't have me, I promise. So it's freebie. I won't remember next semester, I promise. I don't think you're going to have me for property this year. Maybe next year. I'm teaching con law in the spring, which is an upper level, a 3rd semester class. Yes.
You mentioned not using example events, but what if I were to use those after I did the work, right? Something to kind of like,
It's a crutch. It's a crutch. It's very tempting to slide and to do less work and do more outlines. I would just not even own them. I mean, again, you probably already have them. Maybe you bought them already, in which case my advice would be unheeded. But you're going to one day sleep in, one day be really tired. Oh, just read the outline this day, and then you're stuck. Second semester, once you get your grades and we can talk, but you don't know, by the way, all of you, I mean this sincerely, you have no idea what your grade's going to be. You don't know. All of you were good students. That's why you're here. You all did well in your undergraduates. You wouldn't be otherwise. You cannot all be great students here, right? Just a curve. You can't, right? Some of you will get your first B in a few months. You've never gotten a B before, right? You'll get one. Maybe not. Maybe get straight A's, but you're going to be surprised. And by the way, the grades the first semester are not the grades the second semester. People shift. So that's what I'm saying. Your first semester, you might not do so hot. And then you figure out how to correct course, right? My first semester I was top 50% and I graduated at the top, right? I don't know what the heck I was doing, but you need to, the first semester is going to suck. You have to push through it and you have to figure out your way. All right, it's 2:30. I think you have another thing now. What time does your next thing start? Okay, I'm going to stay if you want to come talk to me, but I don't want to hold you up late. It's very important to be played. So anyway, thank you so much and happy answering your questions now if you want to come up.